Hello everybody and welcome to week 5 of the course. And this week we're going to cover the rights of the criminally accused, part 2, and voting rights. So let's get right to it. Just some reminders first. Remember to review all the due dates that were listed in my most recent email to you and that are also listed in this week's assignment folder, because those will come creeping up on all of us before we know it. And just a reminder about my availability during office hours. There's a little link on the left-hand side of Blackboard to click on my virtual meeting room. And also a reminder that this week I'm going to be away with really no Wi-Fi I can depend upon, but I will have service on my phone, so you can use the Google Voice number that's listed on the front page of my syllabus to text or call with any questions. So one thing I want to do first is share my screen and show you how to check your answers on your prior tests, because that's one thing you're going to want to do when you're preparing for the final exam. And if I don't remember to tell you how to do that now, I might forget later on once I start telling you all about the rest of the rights of the criminally accused and voting rights. So to get to this screen right here, I clicked on My Grades, which might look a little different for you guys. So right here where my mouse is wiggling, it says My Grades. And then you'll get something that looks like this, except you'll have actual scores. It doesn't give me actual scores because I'm faculty, not a student. So say here on my week 1 test or my week 2 test, I would see a score right here. And what I would do is actually click on that score that's in blue font, and it would open up the test and show me what I got right, what I got wrong, and what the actual correct answer was. And what you'll also see are little blue bubbles, kind of like the blue bubble you see when a cartoon character is talking. And you click on the blue bubble and you'll be able to see my comments. So just shoot me a text or come during virtual office hours or email me or whatever if you're having trouble figuring out how to do that. All right, so turning back to the right of the criminally accused, part 2, such a broad topic, I had to cover it in 2 different parts. So last week we focused on Fourth Amendment issues like searches and seizures and arrests and warrants and things like that. So mostly Fourth Amendment stuff. We talked about the Fifth Amendment a little bit as far as the right to remain silent during interrogations at the police station and Miranda and all that. So now we're going to shift our focus to things that start happening afterward in the life of a criminal case. So we'll focus mostly on attorneys, trial rights, punishments, so the latter half of the Fifth Amendment and the Sixth and the Eighth Amendment. We'll talk a little bit about double jeopardy, Eighth Amendment protections, and things like that. So just keep in mind that when you look at the world now in 2022, we certainly have a lot of work to do. A lot of people think when it comes to honoring and protecting the rights of those accused of crimes. But if you look at the past, a lot of times poor people got little, if any, protection. You know, we'll look at the Gideon case where indigent people, poor people, didn't get an attorney. They only got one in federal cases. Females really weren't part of the whole judicial process because, up to and through the late 60s, most states didn't even have female jurors, and there were very few female attorneys or judges. Of course, we know in the history of this country, and as we'll talk about a little more, the rights of African Americans were not protected. And then because of the incorporation doctrine, a lot of cases in state courts were not adequately protected. So Remember, the incorporation doctrine refers to the concept that way back when the Constitution was first written, the whole Bill of Rights was certainly seen by everybody to be applicable to the federal government. In other words, the federal government couldn't violate any of those rights and had to honor all those rights and guarantees. But it wasn't guaranteed that state governments and state courts had to abide by all those rights. So as we'll see, it took some time for us to come to the realization that, for example, in state trials, you should get an attorney if you can't afford one, not just federal trials. So just some historical context. All right, so a little bit about double jeopardy, because we don't have time in a 6-week course to go into detail about everything. So I'm going to focus more on the right to counsel when I look at cases. But I just wanted to touch upon a little bit of fact versus fiction, I guess you could say, because most people are aware that there's a general rule in the Fifth Amendment that says that a defendant can't be tried for the same crime twice. And the actual language says, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. But the way it works is a little different than your average person thinks, and there are a lot of exceptions. So, just like the general rule with searches and seizures and warrants, the general rule is that you have to have a warrant or consent, but there are about a dozen exceptions to the rule. There are exceptions to this ban on double jeopardy. There aren't a dozen, but there are about a handful. So, one thing a lot of people don't know is that this right attaches, and by attaches I mean it becomes a reality. It is activated, so to speak. This right attaches either when the jury is sworn in or when the first witness takes the stand in a trial, depending upon what state you're in. It is not sparked by charges being filed. So, say for example, I got tried for this big federal case or state case where I committed some kind of murder, right? And then the state decided they didn't have a strong enough case, or maybe they decided I didn't do it, and later on they, and they dropped the charges, but later on they decided they were going to file the charges again. That would not be double jeopardy. Double jeopardy only attaches when the jury is sworn in or when the first witness takes the stand. It depends upon the state, but it really only attaches or becomes a reality when these trial proceedings actually begin. Another thing some people find surprising is that, for example, a defendant can be prosecuted in federal court for a certain crime, like, say, bank robbery. That's almost always in federal court because the FDIC, they're an agency that guarantees all our deposits in banks, and there's a lot of federal regulations. So, long story short, if you rob a bank, it's almost always going to be in federal court. But stemming from the same incident, there could be some state charges afterward, and it would not violate the due process rule. And that's due to what's called the dual sovereignty exception. And all the dual sovereignty exception means is what I just went over, that you can be prosecuted in federal court for a certain incident and then in state court afterwards, or vice versa, and it doesn't violate double jeopardy. Another thing that can happen, and this happened in the O.J. Simpson case, if you're familiar with that, you could be sued in civil court, for example, for wrongful death, after the conclusion of a criminal case. And that's not double jeopardy, because a double jeopardy clause only concerns itself with being tried for the same crime twice. And yet another thing that most people don't know, if we're kind of thinking about fact versus fiction, is that most states have laws that allow somebody to be incarcerated even after they've served every single day of their sentence and any probation or parole or whatever, even when that's no longer an issue. If you're a sexually dangerous person, that's what SDP stands for. So say you're a serial rapist or a pedophile, and you're somebody who has been diagnosed by qualified professionals as being extremely violent, criminally insane, you can be incarcerated under civil commitment procedures in, for example, some type of psychiatric lockdown facility. So all of these things are true. At the same time, we have these double jeopardy guarantees, but you can kind of look at it as fact versus fiction or exceptions to the general rule, or however you want to look at it. All right, so turning to the right to counsel, this is the right that citizens have in the United States to be represented by an attorney when they're accused of a crime. So the Sixth Amendment states, in all criminal prosecutions, the accused shall enjoy the right to have assistance of counsel for his defense. And way back when these words were written, the law was not that complicated. There weren't that many attorneys, and people could reasonably handle their own cases, although some people did hire attorneys. But things changed as time went on, obviously. And as time did go on, most state courts insisted that this guarantee only applied to federal courts and not state courts. Remember, as I stated a little while ago, the incorporation doctrine came up once upon a time, mostly in the early 30s, where the Supreme Court of the United States and some state Supreme Courts were making it obvious that not everybody agreed about whether or not all states had to provide all Bill of Rights guarantees to people going through state courts. So we kind of operated like a patchwork quilt for a while, even though now, obviously, in 2022, we'll get to the point where we explain that in state proceedings and federal proceedings, if you don't have the money, you have to be provided with an attorney for any crime that could land you in jail. But it took us a while to get there. If you're familiar with the Scottsboro case, which eventually, when it went up before the Supreme Court, turned into the Powell versus Alabama case in the early 1930s. If you remember that case from history class, it was an absolutely horrific case of a bunch of young African Americans basically getting railroaded by the criminal justice system, accused of horrible things, being treated completely unfairly, not being represented in any way, shape, or form that was significant in the lower courts, and it dragged on forever. So if the history of these types of cases interests you, just Google the Scottsboro case and or Powell versus Alabama. And it's not a case that has a very happy ending, because it took a long time for anybody to get any sort of justice, if you want to call it that, and for most people, justice was never served. But turning to the more modern cases, if we want to call 1963 modern, but we have to have, some reference point for modern times. So let's pick Gideon versus Wainwright, the 1963 case, which is the most famous right to counsel case. It's sort of like how Brown versus Board of Education is the case when it comes to fairness and desegregation when it comes to schools. This is equally famous in criminal justice circles as far as the right to counsel. So this involved both Fifth and Sixth Amendment issues, because way back when Clarence Earl Gideon was arrested, he was arrested for robbing a pool hall after it closed, and stealing change and sodas. By all accounts now, it looks like he didn't do it and that somebody else did it who was nearby at the time. especially since he had a set of keys to the pool hall, so why would he smash in the window after dark and take a bunch of change and sodas? You know, it's an interesting case. If you wanted to look up Gideon's Trumpet, it's a free movie you can see on YouTube. But in any case, way back when he got busted for this, he was indigent, he couldn't afford an attorney, he didn't have an attorney when he was being questioned by the police, and when it went through court, he didn't have an attorney either, and he had had some trouble when he was younger, and he had a record, not for anything significant with violence or anything like that. It was just a bunch of petty crimes. And so when he went through court for this criminal case that gave rise to the famous Supreme Court case, when it was going through the lower courts, he had to represent himself, and he did okay. I mean, he didn't have any intellectual disabilities, but at the same time, his case was kind of a tough one because you needed to have certain skills to show all of the factors that indicated he actually didn't do this. And in the state he was in, which was Florida, they had a rule that said special circumstances had to exist in order for you to be assigned a free attorney if you were broke. Special circumstances like it looked like the police or the witnesses were incredibly racially biased, and Gideon was not a black person. He was a Caucasian person. Other special circumstances are like being intellectually disabled, and although he had minimal education, he certainly wasn't intellectually disabled. He ended up being very stubborn and having a lot of common sense, and hand wrote a petition to the Supreme Court to have them hear his case, and he managed to do that. So he wasn't stupid. He just didn't have the abilities that an attorney would have. So he had no attorney at his first trial. He didn't bring out all the information he needed to bring out, and he had to serve 2 years for this offense because of his record. And most historians and scholars now conclude, for a bunch of reasons I don't have time to get into, that he probably did not do this, and it was one of the eyewitnesses was actually the person who did it. So when he was locked up, he wrote to the Supreme Court himself. He went to the library where he was incarcerated, got help from the employee that worked at the library. He managed to get some paper and a pencil, and he legit hand wrote a petition to the Supreme Court and said, my rights were violated. He didn't mostly focus on the Sixth Amendment. He kind of brought up everything, including the kitchen sink. But the Supreme Court focused on the Sixth Amendment, and they assigned him an attorney for the case that was going to be in front of them on appeal in front of the Supreme Court. And to make a long story short, the court decided that this right to counsel should be incorporated. In other words, if somebody in a state court is accused of a crime that could put them in jail, either because they have a record, or they're on probation or parole, or because it's a serious charge, if they are too broke to hire an attorney, one should be appointed to them. So, as a result of this case, Gideon won a new trial. He tried to say, why isn't that double jeopardy? But when you're the one asking for new trial, you can't claim double jeopardy when you get the new trial. And he had a very capable lawyer help him with this new trial. And this attorney he got brought out everything he needed to bring out as far as indications of reasonable doubt, and that perhaps somebody else committed this crime. And he was found not guilty. And again, it's a long movie, and it's kind of old, and the music is kind of cheesy and corny. But it's a really good movie if you're ever sitting around and you have nothing to do and you're bored. Just search up in the little search box on YouTube, Gideon's Trumpet. And when he finally wins his new trial, the great job that the attorney does, and I'm not talking about the arguments before the Supreme Court, I'm talking about the second trial back in Florida. The closing argument this attorney gives is incredible, and they pulled it right from the trial transcript, so it's not just a bunch of Hollywood nonsense. It's a really good movie. So today, what this case means is that if there's any chance of jail time, both state and federal indigent defendants are assigned counsel. So if you shoplift some lip gloss from Walgreens, you are not going to be able to get an attorney, but in other cases, you will. There are other important trial rights that are guaranteed to a person under the Sixth Amendment that we won't have time to get into in any detail, but just as an FYI, you are guaranteed a speedy trial, although sometimes it's the defendants that don't want a speedy trial and try to drag things out because time is an enemy to the prosecution's case, because people either move away or forget what they witnessed or decide they don't want to be involved or whatever. But hey, technically the defendant does have the right to a speedy trial. They have the right to a public trial, which you might say, why would somebody consider it a right to have all this stuff made public? Because some of us might think it might be embarrassing or something, but think about it. In some countries, like in China, they're allowed to do everything behind closed doors. Here, where trials have to be, mostly, in most cases, there has to be an open door policy. Sometimes there are gag orders, and juvenile trials are not open to the public. But the reason why we have this rule is so there's transparency and that things can be fair and not secretive. You're supposed to have an impartial jury. When you first go to court at your arraignment, which is your first stop in court, you're supposed to be notified of the nature and the cause of your crime. In fact, they have to tell you the specific charges and read the charges and the police report, unless you waive that, which some people do because if the police report were read in court, it would sound kind of like the Jerry Springer show and they'd be embarrassed. Another right you have in court is confrontation rights. So, in other words, the confrontation clause is my guarantee, if I'm charged with a crime, that anybody who's a witness against me has to come in court and face me, not send in a sworn statement. They have to actually take the stand and face me and testify against me, so that way my attorney can cross-examine them and raise any reasonable doubt that should be raised. And last but not least, compulsory process. Some people get this confused with a confrontational clause, but it's a different thing. My compulsory process rights are my rights to call my own witnesses to come in and testify on my own behalf at trial. So if my attorney sends out a subpoena to some witness that could maybe help me in my case, that attorney has to come in and testify at my trial. So turning to the Eighth Amendment, the Eighth Amendment pertains to what is, in italics and quotes up top, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. However, cash bail still exists. And what I mean by cash bail is, say I got arrested for assault and battery and I got into a huge fist fight with somebody and I beat the daylights out of them, which is not likely to happen because I'm about as tough as a bag of marshmallows, but let's say that did happen. What the judge would do in order to guarantee that I would show up in court again, he or she would require me to post bail, a cash bail, like let's say $2,500. So let's say I have $2,500 on my bank account. I can post that and the court hangs on to it until the case is done. They're kind of holding that money hostage to guarantee I show up in court. And if I didn't have that money in my bank account, I could put up the deed to my house or something like that. The reason why cash bail is controversial is that, say if I was 25 years old, I didn't have $2,500 in my bank account and I didn't have a house or a deed. So it's seen as kind of lopsided and favoring people who have money and people who don't, when fairness and amendments are supposed to depend upon, you're a citizen who lives in the United States and you're innocent until proven guilty, and it's not supposed to be different degrees of fairness based on the size of your bank account. It's a similar issues with fines. So say there was a certain fine for, say I burned a bunch of stuff in my backyard and there was a $2,000 fine for that, and I showed up in court and I said, okay, Your Honor, I'm guilty, and they said, fine, just pay this fee or fine of like $3,000. It's $3,000 for everybody. It doesn't matter if I won the lottery and I'm worth, $800 million, or if I make $60,000 a year as a social worker. That fee or fine is the same for everybody, when some people think maybe it should be based on income or sliding scale or something. So cash bail and uniform fines, regardless of income, those do not violate the Eighth Amendment. At least the Supreme Court hasn't said that it does. Additionally, those who advocate for prison reform, they allege that certain things that are conditions in everyday life in jails and prisons violate the prohibition against cruel and unusual punishment. And some people say that there should be cases going in front of the Supreme Court that declare certain things unconstitutional. So, for example, most of the time in jails and prisons, the food they get is stuff that you kind of like just add water to. And some of them say not fit for human consumption on it. There's been a lot of cases where, bugs and things have been found in the food. As far as the calories or portions, they're the same for everybody, whether you're a 5'3", 100-pound woman or a 6'5", 250-pound guy. So the portions, some people allege, are toddler size. Those things with the food do not violate the Constitution. Maybe they do in theory, but until somebody brings up a case and the Supreme Court says it does, it's not an Eighth Amendment violation right now. Something that's coming up a lot now as temperatures get warmer and warmer. Picture in states down south being in a facility that is not air conditioned and there's no fan. So the ACLU has filed some cases on behalf of some inmates saying that it's cruel and unusual punishment to not even have, a fan or an open window or anything except stagnant air if you're locked up, say, in solitary confinement and the temperatures in your cell are exceeding, like, say, 125 degrees and you're fainting and passing out and having to go to the infirmary and get an IV or something. So right now, that's the status quo, and there aren't any cases that are overturning that. And in some states, according to their own rules, they will have a fan or AC or something like that. But some facilities just aren't as good at taking care of things like that. So we're going to look at the death penalty more in depth in a minute. But basically, the death penalty is allowed if certain conditions are met, depending upon what state you live in, and if you want to say what states, if you want to see what states have the death penalty and which ones don't, you can click on that link. Most people know that Massachusetts does not have it. A lot of New England states don't have it, and a lot of southern states do. So looking more specifically at certain death penalty cases, the death penalty was legal in the United States for centuries, and looking at a starting point of 1972, the Supreme Court, in the case of Furman v. Georgia, they banned the death penalty absolutely, outright, for a period of about 4 years for a wide variety of reasons. Basically, there was no uniform process or set of procedures to make sure that the courts and the juries were applying the death penalty as a sentence in any sort of fair way. There was no set of standards or best practices, and there was no standards set up for, what types of crimes or charges could this be considered for. So about 4 years later, in 1976, the case of Gregg versus Georgia served to clarify certain things, and the Supreme Court of the United States said that the death penalty was constitutional once again, if and only if a couple of conditions were met. One thing is there had to be this bifurcated procedure, and what that means is a two-step procedure where if somebody could be sentenced to the death penalty, there was one phase where the jury decides if the person is guilty or not guilty, and then there's an entirely separate procedure afterward where it's decided whether or not the death penalty or life in prison is an appropriate sentence, and the defendant gets to present all kinds of evidence on his or her behalf. The other thing that this Gregg case made clear is that you can't give the death penalty sentence for cases like rape or child molestation or something like that. It has to be for murder charges. Some more recent cases that have come up that have clarified the parameters of the death penalty are the Atkins versus Virginia case in 2002. And back in 2002, the courts were still using phrases like mentally retarded, which really is an insensitive type of term to use today. That's not the preferred term. We use intellectually disabled. But when you go to look at the case, they use the phrase mentally retarded, and that's mostly a legal term rather than a medical term or a diagnostic term. And it's used to describe situations where, for example, in a certain state, they would identify somebody as being mentally retarded if testing showed the person had an IQ under the score of 70, for example. So states would have their own way of determining what mentally retarded meant, and that was the verbiage that was used back then. But usually, that's a pretty common one, that somebody has an IQ under 70, and if that's the case, they would be deemed what we would now say intellectually disabled, and the death penalty could not be used as a sentence for that individual. In 2005, the Roper versus Simmons case was decided, and in that case, the Supreme Court decided if you were under 18 at the time a crime was committed, that the death penalty could not be given to you as a sentence. And that's even if the case was a murder case. Okay, we're going to transition quickly to voting rights because I'm trying not to make these videos too long. But just one last word about the rights of the criminally accused. Most states like Massachusetts are undergoing really significant reforms. Like Massachusetts, about a year ago, had a police reform bill passed. If you just looked up summary of Massachusetts police reform bill, you'll see that Massachusetts is pretty typical, like most states, where significant reforms are taking place. So, speaking of the news, voting rights are also in the news every day, mostly due to things like, a lot of states are passing more restrictive voting rights legislation. The big lie is still in the news every day because of the January 6 hearings. The big lie referring to the claim that the 2020 election was stolen. There have been some conspiracy theory videos that have been put on YouTube that have been disproven. And COVID was a big factor in all of that because it was due to COVID that the mail-in ballots came about. So, in response, it's become a very red and blue issue, meaning a very Democrat versus Republican issue about what restrictions we should have around voting. So states like Massachusetts have expanded mail-in voting rights, absentee ballot rights, and other states have increased voting restrictions. So what I'm going to ask you to look into, what you can look up and discuss in your discussion board this week, is what's the big deal with mail-in voting and voter ID laws? Some people think that mail-in voting leads to fraud. Other people don't. The research indicates that it does not. And voter ID laws seem to be something that's of little consequence to some people, but other folks think they're unfair because it's only the most needy and disenfranchised that aren't going to be able to afford an official government photo ID if they're in a certain financial state where they are indigent, and that would prohibit them from voting. So I'll let you do your own research and thinking, and I'll even provide a link to guide you in this week's discussion board, because that's an interesting and significant thing to look at. What's the big deal with mail-in voting and voter ID laws? A lot of people don't trust mail-in voting, so it's good to look at what the research shows, and I'm talking about things that have been vetted for accuracy. And it's also good to look at voter ID laws and see what impact those might have, especially on communities of color and people who have been historically excluded from the political process. So, one thing that is coming to the forefront of all the media attention now, you'll hear it on news radio and on TV and on social media, is this independent state legislature theory. And it's something that's going to be coming before the Supreme Court soon. But basically, the elections clause of Article 1 has significant and specific language when it comes to the role of state legislatures when it comes to federal and state election rules. So what the elections clause in Article 1, Section 4 says will be quoted in this week's test. You'll get to look at the language. But basically it says that state lawmakers create the rules for their own elections and some basic rules for federal elections, and that's fine. But that Congress, the United States Congress, essentially has the last word and can revise those rules and regulations. What this independent state legislature theory promotes, and it's supported by those of the conservative persuasion, is that the state legislatures should have the last word, which seemingly contradicts the language of Article 1, Section 4. So I'll let you look at the language in the cases and decide for yourself. But let's look at some major background cases that have to do with elections, and that will allow you to look at that through a more informed lens. All right, so before we get to the actual cases, and let me adjust my view here, remember back to Voting Rights 101, right? As we covered previously last week, the 15th Amendment was supposed to make clear that African American people have the right to vote, regardless of whether or not they were enslaved persons, that, any prohibitions on voting were done away with. So that was supposed to give black folks the right to vote. But after that, people who advocated Jim Crow laws and the black codes tried to find loopholes around these post-Civil War amendments and throw up barriers to black folks voting anyway. After that, the Voting Rights Act of 1964 did away with things like poll taxes and literacy tests and all other kinds of ridiculous barriers to voting. Additionally, the 19th Amendment, which was not ratified until 1920, guaranteed the right to vote for women. So let's look at these three major voting rights cases. The first one is the Bush v. Gore case that happened in the year 2000. And this case is one that conservatives loved, and it's one that on its face seems to contradict the independent state legislature theory. But in any case, this is the very famous case that gave George W. Bush the election and made him prevail over Al Gore. So that election was essentially decided by the Supreme Court. What happened was it was a really close election. It seemed to be coming right down to a tiebreaker situation, and the electoral votes in Florida were going to decide whether or not Bush won or Gore won this election. So if you don't know how the Electoral College works, basically we don't have a one-person, one-vote system here in the United States. Each state is assigned a number, and that number represents how many people you have in the Senate and House of Representatives. So let's say, for example, Massachusetts has 11 because we have 2 senators and 9 people in the House of Reps. So if, for example, Al Gore were to win Massachusetts in the year 2000, he would get all 11 of those electoral votes. So in any case, they had this voting machine in certain parts of Florida where when you push the lever and decided to vote for Bush or Gore, it left, instead of punching the paper clean through, it left these little hanging pieces of paper. And when this really close vote had to be recounted by hand, the little thingies of paper hanging off made it allegedly tough to tell who the person was voting for. So the Florida Supreme Court was working its way through that and said we have to do a manual recount, an inspection in the certain area of Florida that's going to be the tiebreakers, the tie-breaking count for all these electoral votes. The Supreme Court decided, hey, Florida Supreme Court, it's not your call, it's our call in the federal government, and we're going to award all those 25 electoral college votes. It's a bigger state, that's why they have 25 electoral college votes. We're going to put a halt to this whole procedure you're trying to do. There's not enough time to implement any plan you're going to try to have. And this ensured George W. Bush's victory over Al Gore. So this was controversial for a number of reasons. There were issues of state versus federal authority. There were equal protection and due process issues brought up that you will see when you read the case or review the case summary. Conflict of interest issues because, lo and behold, George W. Bush's brother was the governor of the state of Florida at the time. And incidentally, President Trump wanted to rely on this case to help him in 2020 when he was claiming the election was stolen. He was hoping the Supreme Court would use this as precedent and declare a bunch of mail-in ballots invalid and, win the election. So I'll let you look at that in more detail about the controversy. But it was a landmark decision for the number of reasons I've spelled out, but mostly because it had to do with issues of states' rights versus federal rights. And it would seem that according to this case as precedent, and it hasn't been overruled, that this most recent theory that states rule supreme when it comes to all manners of elections, that wouldn't work. All right, another very important case is a Citizens United case, and it's what a lot of people think is one of the most important cases when it comes to voting rights. So there are certain rules about how much somebody can contribute as an individual to a political campaign. Right now it's $2,900. I don't recall off the top of my head what it was in 2010, but I think it was something like, $1,700 or $1,800. But it will say what it was in the case summary. There were also rules back then, and still are certain rules about how close to a political campaign you can air something that's called like a smear ad, attack campaigns. So there was this conservative group called Citizens United that came out with this lethally critical campaign. It was pretty much like a movie documentary type of thing that really was kicking Hillary Clinton in the shins, so to speak. And because of these campaign finance rules and these rules about having attack ads so close to an election, the Federal Election Commission, the FEC, who's in charge of these rules I was just talking about, stopped Citizens United from promoting and airing the film. So what happened in a 5-4 decision of the Supreme Court, and that's significant, that means only a slight majority agreed with this thinking. They sided with Citizens United, saying based on First Amendment issues, you can't say no attack ads can be run right before an election. That violates the First Amendment, which to most people makes sense. Hey, First Amendment rights, you should be able to air attack ads at any time. But the thing that a lot of people didn't agree with is they said that First Amendment protections and guarantees were provided to corporations, nonprofit groups, and unions when it comes to how much money they can contribute to individual campaigns. So you'll see when you review the case that First Amendment protections were given to corporations, nonprofits, unions, and entities that are not citizens, right? So we usually think about the First Amendment applying to citizens and that it applies to words, but I guess it applies to these non-individual entities, and it also applies to money and how much money people can contribute. So you can look that over and see the exact definition of super PACs and how super PACs were born and the resulting consequence now of unlimited corporate money being funneled into politics, as long as it's one of these groups, not an individual, and as long as it's given to a super PAC, not the candidate directly. So, most of us would want a world where there's an even playing field, where maybe, I'm picturing in my mind's eye some really cool individual running for the presidential election in the year 2024. Maybe somebody unknown. Maybe somebody who's not so tangled up with either side, the Republicans or the Democrats. Somebody who's not just after money and a power grab. Me and my little fantasy world thinking of somebody who has the best interests of our country in mind, right? Now, what chance does this hypothetical outsider have when they're competing with people on both sides? Both sides are just as bad on this issue, right? Funneling tons of money into their candidate. This new untarnished outsider that some of us wish we could have to vote for, they don't stand a snowball's chance in hell of getting anywhere in our system without money, especially when unlimited money can go to people that have been so entangled in our system for decades. So it's a decision a lot of people aren't happy about. All right, the last case we'll look at is the Shelby versus Holder case, and this is controversial for a number of reasons. The Voting Rights Act of 1965 had some certain provisions that were meant to last a long time. And a certain provision, Section 5, was supposed to remain in place indefinitely, some would argue, that said certain districts that had a lot of issues and troubles in their past when it came to racial discrimination and gerrymandering, that they had to get pre-approval from the feds before making any changes to their election laws, the way they carved up districts, or their voting procedures. They had to get federal approval of these changes pre-authorization before they could make those changes. And the reason why this sort of butting in to state elections took place is because the districts that were still living under this Section 5 had a huge history of being racist against black folks, huge history with gerrymandering, which is carving up a voting district a certain way just so you can kind of achieve a certain predetermined result, right? Like preventing a certain group of neighborhoods that had a strong black vote from having their candidate win. So Shelby County in Alabama filed suit so that they no longer had to live under this Section 5 restriction. And the Supreme Court agreed to strike down, not the whole Civil Rights Act of 1965, obviously, but this Section 5. So they agreed with the plaintiffs, and they said that this particular provision violated 14th and 15th Amendment guarantees, as well as certain states' rights guarantees of the 10th Amendment. So this ruling has been in place since 2003, and since 2003, we've seen many states, mostly in the South, not always in the South, but almost always states that have a huge history of issues and unfairness when it came to enhancing and protecting voting rights of all Americans. The reasoning the Supreme Court had in this decision, when you look at it, they said, well, maybe that was an issue long ago, but it's not an issue anymore. However, what we've seen are polling places and voting booths being shut down in historically black neighborhoods. We've seen all kinds of really funny redistricting of certain historically black voting districts. So critics of this decision would say the language that says, oh, we don't need to worry about this stuff in 2013 and after. All this racism stuff has gone away. A lot of people would be critics of that. And a lot of people would say it results in voter suppression. And voter suppression is any act, whether it's purposeful or incidental or consequential, which results in fewer people being able to vote. So a lot of people would consider, obviously, racial gerrymandering as voter suppression because it has effects on the consequences of elections. A lot of people would consider voter ID laws and other things I've mentioned as being voter suppression. So the results of the Shelby decision are coming into play and being more and more obvious with each passing day, and are continuing to be more and more obvious as we head into the 2024 election, and a lot of left-leaning civil rights groups amping up to the 2024 election are trying to change things. So in states like Massachusetts and most New England states, it's not a concern because we're such blue, liberal, left-leaning states. But in other states that are historically more right-leaning, like if you were to look at a map and see what states were part of the Confederacy in the Civil War, those are the types of states where we're seeing more and more laws that many allege are restricting voting rights, especially for communities of color. So it's easy to get complacent living in a blue state, but I would urge you not to. Just like I wouldn't say, oh, who cares about the Dobbs decision? I live in Massachusetts, so my reproductive rights are protected. Well, for example, I'm not in a stage of life where I have to be worried about that anymore, but I still care about my younger sisters, just like I'm sure any females or males listening to this are concerned about people that live in red states. And the same type of mindset most people would agree applies to some of these voting restrictions. Even if we're not worried about it here in Massachusetts, other states aren't as lucky. All right, so keep these things in mind as you go forward and go to answer the Week 5 quiz.